Good day, folks. My name's Ed McFerran. You may have seen one video from me up to the present time. This video is intended to help and assist and give you some additional background information regarding the closing of your first or second or potentially third relinquished property. Keep in mind that there's no limitations as to the number of properties that you relinquish in your tax-deferred exchange. There's also no limitation in the number of properties that you actually replace. Many of our clients will relinquish one or two and buy one or two. Commonly, we'll relinquish one and acquire what we call a replacement property, one other replacement property. This time we are working and closely assisting the escrow people for the completion of your transaction. It really doesn't matter whether the transaction's in the state of Washington, Arizona, Texas, or Wyoming. Our services under federal law extend through every state of the United States, Alaska, Hawaii, and the Virgin Islands, and all of these states are available for your tax-deferred exchange. We need not be concerned as to what state we're operating in. However, each state does close transactions in a slightly different fashion. Our goal, again, as we said in our other video, is to provide a tour guide relationship with you to help and assist you as we move forward in this next part of the transaction. You may recall that we took efforts to obtain from you a copy of your purchase and sale agreement, either from you directly or from your broker in the transaction. We also have been in communication with the title company or the attorneys or the escrow company, depending upon the state in which your property is closing, and we've been working closely with them to provide what we call exchange escrow instructions to them. You may have seen those come through our office as a courtesy copy. You may not have seen those, but they direct and tell the escrow folks exactly what they need to do in order for your transaction to be completed as a qualified tax-deferred exchange. If you look closely at the agreement that you entered into to sell the property, you'll find that it said purchase and sale agreement or some derivation, therefore, that talks about a sale of the property. And of course, we can't have a sale of the property. So let me tell you how this all works. We prepare legal documents as attorneys for the transaction in which you, as seller, relinquished all seller's right, title, and interest in the purchase and sale agreement to our company as qualified intermediary. We do this to meet the 1031 rules promulgated by the Congress and interpreted by the Internal Revenue Service. This document is an assignment of the purchase and sale agreement signed by you at escrow and also signed by your purchaser at escrow agreeing to cooperate with you in the completion of your tax-deferred exchange. Our escrow instructions to the title and escrow folks are detailed in nature, and they will provide very specific instructions on how they need to complete the transaction. We will be monitoring their process in so doing, and we will review all documents related to the transaction's exchange qualifications. We are not reviewing the transaction for anything other than exchange qualifications. Keep in mind, our services as qualified intermediary do not replace the services of your potential attorney, tax advisor, or other trusted advisors. We are hired and our services are limited in scope to reviewing the transactions for compliance with the Section 1031 rules. I think it's important to understand the scope of our services. Those instructions to the escrow folks are specific, as we said before, and we'll provide them the necessary information for them to prepare legal documents to convey the property to the third-party purchaser, as well as to prepare a settlement statement that states with particularity the details associated with the financial aspects of your transaction. By now, by the time that you're reading the documentation and seeing this video, you will probably have a variety of questions that come into play. I'd like to spend a couple minutes, if we could, taking a look at the issues of what we call allowable closing costs and non-allowable closing costs. This is an issue that comes up at this stage of many of our clients' transactions. And I'd like to spend just a couple minutes so that you understand what is an allowable closing cost and what is a non-allowable closing cost. Humor me for just a minute. I won't take up too much of your time. but this is an area that we need to understand clearly. The tax-deferred exchange is the sale of real estate. In the sale of real estate, matters associated with those incidental costs such as title fees, escrow charges, excise tax in the state of Washington, recording charges, all of those types of transfer fees that may be applicable to a real estate transaction are what we call allowable closing costs. By the way, commissions are allowable closing costs. I should also tell you that our fee as a qualified intermediary for your transaction is also an allowable closing cost. Prorations of real estate taxes are deemed to be an allowable closing cost as well. However, there are some matters that are not specifically an allowable closing cost, to which we refer as a non-allowable closing cost. This will surprise many of our clients, and in our instructions to your escrow officer, we directed the escrow officer to exclude from the settlement statement certain non-allowable closing costs. What are they? One non-allowable closing costs that shows up on a pretty regular basis are security and damage deposits. Let's assume for just a moment that you have a tenant in a commercial property or a residential property, be it as it may, and that tenant has deposited with you, let's say $500 as a damage and security deposit. That damage and security deposit is really, well, it's really the tenant's money, and it's also monies that you're typically holding in a separate account. Those monies are what we call operational monies and really have nothing at all to do with the purchase of the property. It has everything to do with the tenants who are living in the property. We generally suggest and require that the seller, in this case you as an exchangor, will transfer those funds to the buyer, typically outside the closing of the transaction, at least outside the settlement, because those costs and fees have nothing to do with the actual purchase and sale of the property. In like fashion, prorations of rental amounts from the tenants are an operational aspect of the transaction and are not, they're a non-allowable closing costs. So these too will be handled by the parties outside of escrow. There may be some other non-allowable closing costs as well, but in the sale transaction, or what we call the relinquished property transaction, these two, security deposits and prorations of rents, are probably the two hottest buttons out there as far as what we call non-allowable closing costs. In our escrow instructions to the closing officer, we're going to ask that they exclude those from the settlement statement and ask that they be included in a transfer by you to the purchaser outside the closing of the transaction. What happens if these particular costs are included in the transaction? Well, to the degree that they are included, they can result in a taxable event for you, not necessarily creating a defect in your overall tax-deferred exchange, but to the degree that you receive a benefit, such as not having to transfer a security deposit out of another account to the buyer, and that account comes from you, that type of benefit is going to be deemed to be what we call boot. Boot is a term of art in tax-deferred exchanges that says that there's a cost that's being paid for by the exchange that should have been paid for by you, for which you are receiving a benefit, that doesn't cause the exchange to fail, but causes you to receive a benefit, and as a result you would pay tax on those what we call boot monies. Again, our overall goal as your tour guide is to help you and assist you in completing what potentially could be 100% tax-deferred exchange with no capital gains tax to pay whatsoever. In order to accomplish that, we need to address the issue of boot as an integral part of the closing of the transaction. I've kept you long enough, but we need to talk about one last subject before we're done at this stage. And I think it's an important subject, and it's a subject that comes up on a pretty regular basis right before closing. Clients cannot get money from an exchange whenever they wish to receive the money from the exchange. Once your exchange property closes, the money stays in the exchange account under federal regulations for at least a period of 45 days, unless there's an acquisition property closing within that time period. You cannot call our office and ask for a withdrawal of those funds at any point in time during the 45 days. There's only certain specific times where you can receive money from the exchange. Again, receipt of money from the exchange does not cause the exchange to fail as long as it's done within a prescribed time period, but it is money upon which you're going to pay capital gains tax. Again, we call this boot money. If you wish to have some money come to you, there's only 4 times during the exchange that it can come to you. For purposes of this video, we're going to talk about the first time. It can come to you at the closing of your relinquished property transaction, but we need to know ahead of time what dollar amount you want to have come from the closing. It has to occur at the escrow of the closing of your first relinquished property or second relinquished property, and can only come at that time. So we need to know about it ahead of time. If you want to have some boot money, we need to send specific escrow instructions to your closing officer to make sure that they have this information in hand well before the closing. If this information is not addressed, no boot money will come from the transaction, and the transaction will hold all funds during the course of your exchange. Again, as usual, you will potentially have some questions. Our staff is available from morning until evening. We're available via fax, we're available via phone, we're available via email, and all of our staff is available to you to answer your specific questions. This goal of this video, of course, is to provide you some general information, but it certainly doesn't replace the information that we can help and assist you with in your particular transaction. Good day.